It will be perfectly understandable when you open that email with allegations of serious misconduct to feel really overwhelmed by what you're faced with. Senior leadership are going to be asking you many questions. How do we handle this? How quickly can we deal with this? What does it mean for our reputation? What's the PR that we need to think about? Will our regulator need to know about this? What's it going to cost us, and what's our risk? But if you plan really carefully for a workplace investigation, although it has many different angles and interests that you need to be mindful of, it doesn't have to be the worst thing on your to-do list. I'm Jo Chatterton. I head up the employment team at Fox Williams, and I'm here with Sona Ganatra, who co-heads our financial services and regulatory team. And we're going to highlight to you some of the key things that you need to think about at the beginning of an investigation, to help you manage that process effectively and efficiently, to help you balance all the different interests that are at play, to help you answer all those questions from senior leadership, and also to be mindful of your legal and regulatory risks. So Sona, what do we need to think about in the first place?
Thanks, Jo. So from our experience, there are a number of key things that you should be thinking about right at the outset when you receive that allegation. The first one is thinking about the scope of the investigation. So when you receive that allegation, before jumping in, it's really important to take the time and consider the complaint really carefully. So what sorts of issues are coming through? So thinking about, is it historic? Is it continuing? Does it involve regulatory breaches or potential criminal ones that we've come across in our experience? And once you've had that time to think about it, that will really help you prioritise what immediate steps you need to take, because you may need to do things such as suspend employees, which Jo, you'll speak about in a moment, or you may need to notify a regulator or indeed the police. So once you've had that time to think about the allegation and think about the issues that are engaged, you can start to consider what sort of scope of the investigation may be. And when you're thinking about scope, it's really important to consider what outcome you're trying to achieve. Of course, you're going to be really concerned about making sure that anyone that's committed wrongdoing is sanctioned and that your business is able to respond and work out whether there's been any governance failures. But you'll also be really mindful to mitigate the risk of litigation, of regulatory intervention, and of course any negative publicity that may come along. So thinking about the scope in this way will make sure that anyone that investigates this allegation will be able to really focus on the right issues, and it will mean that you're then able to give really clear and concise messages to all your stakeholders and making sure that they're really certain that you're dealing with these allegations properly. So once you've decided who's going to lead the investigation, you've then got to start thinking about planning those interviews and gathering the relevant documents. So there's lots of different ways you can approach this, and it really does depend on the nature of the allegations and the detail of what you're trying to get through. One thing that I found that's really helpful is to adopt a phased approach to interviews. So that means conducting a few limited fact-finding interviews right at the outset. And the reason for doing that is it will enable you to gather all the detail that you need, and it will help you formulate your strategy going forwards. And then what you can do once you've got that initial information, you can then schedule in the more substantive interviews with all the relevant individuals. When it comes to gathering in the documentation, where we've seen things go wrong is where that's really thought about as an afterthought. And so by the time people get round to looking at the relevant materials, they've been lost, misplaced, destroyed. And so it's really important to think about that right at the outset and think, how can you get those physical copies secured and put away so that they're ready for you to consider later on down the road in the investigation. You may also want to think about engaging with forensic teams or your IT practices so that you can start really making sure that you're securing those electronic documents that could be relevant too. And one thing that I think from a practical perspective, it's important to look at what technological tools you can use to really make sure that you're dealing and searching through documents quickly. And there's lots of tools available at the moment that will make sure that you can really hone in on those key documents and make sure that your investigation runs swiftly. Before I hand over back to Jo, one last thing to think about is how your investigation sits alongside any regulatory interest or potential investigation by a law enforcement body. So let's say you operate in the financial services sector and your regulator, the FCA and or the PRA, you will owe them obligations to report or notify them of particular issues. So think about who's going to conduct those notifications and what information do they need to make sure that they're going to allay the concerns of the regulator. And the key really is to make sure that the regulator's kept updated at all times so that they know that you're dealing with the allegation at hand appropriately and comprehensively. Because where we've seen difficulties come through, it's where the regulator gets concerned that you're not dealing with these issues properly, and so that they may then start an enforcement investigation or they may appoint a skilled person. And both of those outcomes are ones that you really want to avoid. The other aspect, of course, is if there's potential criminal issues involved. The police, the SFO, or indeed the FCA and other bodies may want to start an investigation. And it's really important that the steps that you take don't prejudice a criminal investigation. And so what you should be thinking about is making sure that you're getting advice and you're really comfortable that the steps you take in your investigation don't interfere with that criminal investigation. So Jo, I'll hand back to you now.
So I'm going to talk, Sona, about some of the employment aspects of an investigation that you need to think about at the beginning. And one of the first thoughts that you will have is whether you need to get the person accused of serious misconduct off the premises. Even if you have a right to suspend in the employment contract, that right has to be exercised only where there is good reason to do so and not in a knee-jerk way. And that's because you might put yourself in breach of contract by doing that, because it's recognised that if an employee is suspended, that can have a significant impact on their relationships with colleagues, with clients, for example, and also in connection with their mental health and well-being. So you need to apply your mind to whether a suspension is in fact the right thing to do and is necessary in the circumstances. And good reasons to suspend might be because you're worried about having people within the workforce together interacting potentially with each other when one is the accused and one the accuser. You might be worried about the destruction of records and documents, for example, or interference with witnesses, particularly perhaps by a senior individual within the business. And once you've made your decision, it's good practice to record that in writing. And you should also give thought to and record that you've done so, whether there are any alternatives which are less impactful than a suspension. So, for example, asking the accused person to remain away from the office and work from home, or perhaps limiting access to certain databases and documents so that there's no risk of them destroying evidence. You also need to think at the outset about how you're going to support people involved in the process. And that's not just thinking about the person who's made the complaint, it's also thinking about the person accused, it's thinking about everybody who might be interviewed in the process, and of course also those who are conducting the interviews or taking notes, for example, because some of the material that we've certainly dealt with in investigations is actually very upsetting and difficult for people to hear. So everybody, you need to give thought to everybody in that process. It's important that you don't just assume that you know the support that each individual will likely need. We'd suggest asking them what support and help they can give, you can give. That's not necessarily it's not necessarily the case that you have to do everything that they ask you to do. But you can take a decision as to what's reasonable. But what you don't want to do is, for example, be accused of breaching someone's contract or perhaps victimising them for having raised complaints when you ask somebody to leave the premises because you think it will be in their best interests and well-being to do so, whereas they might see that as being a punishment for having brought serious matters to your attention. Also, a really easy trap to fall into is that you give priority to looking after the complainant but not the accused. They're both your employees. They should both have access to employee assistance programmes, etc. in the same way. You also then need to think about who is actually going to be involved in the investigation process alongside the investigator. And I think this is particularly important where the investigation is being carried out by individuals within the business. But in any case, you do need somebody coordinating the whole process. And that person needs to be someone who is senior enough to be able to interact with all the various stakeholders, including very senior people within the business, and of course to be dealing with lawyers and other advisors in the process. The other thing you need to think very carefully about, because of the issues around confidentiality, is who actually needs to know about the investigation. Adopting a need-to-know basis is what we would recommend, but really engage with who really needs to know. No non-executive director or board director is going to thank you if there is a serious issue which becomes public. They're asked questions about that, perhaps by a journalist, for example, and they haven't been briefed on the situation or don't know that it's arisen. So think very carefully about the particular matter that you're dealing with, the potential for publicity, and who needs to know, and be briefed about that. It's very important as well, obviously, to talk to everybody that's involved in the process about the need to keep things confidential. But equally well, it's very difficult to guarantee confidentiality. Clearly, the more people are involved, the greater the risk that somebody will mention something. But when you are asking people to keep things confidential, you have to be really careful to manage their expectations about what might happen, particularly if something becomes litigious, and it's very difficult to keep their name out of the process. Having said that, I think although it's good practice to sort of warn people of those risks, you shouldn't do so in such a way that you effectively are seen to be putting people off raising those concerns. Because again, they may have valid cause for complaint that you are trying to sweep things under the carpet, for example. And it's those kind of concerns which sometimes drives people to publicise or take matters outside the workforce to the press, for example, or even to a regulator. And it may mean that they feel, if they're particularly aggrieved, that they want to speak to other colleagues, and therefore it will be very difficult to make sure that things are being kept confidential. Finally, a kind of really important point is to make sure that you keep everybody informed about how the process is going. One of the reasons that we see people going to regulators, going to the press, talking to colleagues when ideally they shouldn't, is if they feel that they've made a contribution but they can't see what's happening in the process, so they don't know where that information is going. They don't know whether they will be asked for further information. They don't know any sort of consequences for them. So ensure that throughout that process you keep people informed. That obviously doesn't mean disclosing to them confidential information about who you're talking to, etc., but giving them an idea of timing and when they can expect things to happen, and maybe if you don't need any further information from them, letting them know that that's the case.
Thanks, Jo. So we've run you through some of the really practical things that we found helpful to think about right at the outset of an investigation, and the sort of pitfalls that you can try and avoid as you go through. The key really, I think, is when we look back at the investigations that we've worked on, is to make sure that anything that you do is planned, is proportionate, and that you deal with issues swiftly and seek the support and advice that you need as you go through. And if you can conduct an investigation in that way, then hopefully it will run smoothly and you'll be able to mitigate the risks that we've talked about of potential litigation, negative media, and regulatory intervention. Thank you.